Welcome yet again to our ongoing YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we're going to discuss some of the things you should consider doing should you have been sued. So the first thing to do is not to panic. You don't want to take any rash actions, take anything hastily, make any decisions without properly having considered them and having spoken with legal counsel. You want to take prompt action, but you want to be taking the right prompt action, the correct action. But you don't want to be pulled in from your adversary's side or from any false expectations as to you're having to communicate immediately with the other side and trying to resolve this. You really need to take a step back, consider what the situation is, and really contemplate what is being sought from you and what you should be doing, particularly should you, and we suggest it, retain the services of knowledgeable and experienced legal counsel. This is critical to the process you're going to do. So, the next thing is you don't want to start communicating with the other side. Yes, there's going to be communication that's going to be undertaken, but you don't want to immediately say, what the heck is going on? Why did you sue me? How do we resolve this? Like I said, take a step back, consider what's happening, engage legal counsel, and don't speak to them before you've talked to the lawyers. And the reason you don't speak to them is because those communications you have with the other side are not protected by legal privilege. So those initial communications you have with the other side, and even that you have with other people, are not going to be legally protected. What you want to instead be doing is speaking to your lawyers and getting your lawyer's directions as to the manner in which you undertake communications going forward, because it's absolutely critical and essential that you retain and you protect your legal privileges with respect to your communications, because the last thing you want to do is you do not want to be further mistaken and misinterpreted, as might well have been the case previous to that, or otherwise contradict yourself. So given that fact, you want to be taking your time as to who you're communicating with and communicate with the correct people in the correct order. Now, when it comes to evidence and materials, you want to be protecting and safeguarding all the evidence that is pertinent. The last thing you want to do is feel that you're under threat and start destroying stuff. Destroying, discarding evidence, doing anything to make it more difficult to find is going to work against you. The reality is, in today's day and age, it's so much of this evidence can be reproduced, can be found, and also the fact that you've got this timeline, and as soon as you receive the complaint, as soon as you receive the statement of claim, the lawsuit, you're on the under an obligation to the court to not destroy an evidence. And the fact that there is gaps that are created after you have received the lawsuit is going to put you in a very difficult place with the court. Something that might have been easily explained can be misinterpreted, can be worked against you in such a way that you do not want to discard anything. You don't want to throw it all out at the other side. That's not what I'm saying. But what I'm saying is you want to retain it, you want to review it with your lawyer, and you want to deal with it properly. You don't want to have created gaps or other things that can give the other side the ability to present you as dishonest and disreputable, because that's going to work to your disadvantage. Similarly, you're going to want to start preserving and protecting your memory. You're going to want to subject it to privilege, but you don't want to forget key thoughts. So you want to be talking to your lawyer, finding out how best to preserve those thoughts, to preserve your recollection. Because the fact of the matter is that your best recollection is going to be now. It's not going to be later in the process when time has passed and other aspects have been brought in that challenge your memory or challenge the facts, especially given the way that the legal process works so slowly. You could be looking at 2, 3, 4, 5, even more years until you actually get to trial. And when is your memory going to be better? Well, it's going to be a lot better right now as opposed to several years from now. And if you have those notes and you refresh your memory before you go into questioning, depositions, meetings, advising your lawyer, and most especially at trial, you're going to be that much closer to what the real facts are, and you're going to not look like you're being evasive, you're misrepresenting facts, or you're being incorrect. Your memory now should be as close as possible to what the actual events that transpired are. So you want to preserve that memory in the way suggested to you by your lawyer. Next, you want to notify your insurance provider where insurance is applicable in the matter. You don't want to be waiting. Your insurance carriers have clauses within their insurance policies where if you delay, if you are late to provide them with notice, you could forfeit your insurance protection. You never want to forfeit your protection provided by insurance. You want to make sure that it is always available to yourself. And the other thing is that you want to make sure you confirm in writing and get confirmation from them with respect to your engagement and communications with them. Because the fact of the matter is that oftentimes the first person you speak to at your insurance carrier will tell you that there's nothing much that can be done. That, however, typically happens in a phone call. What you want to be doing is, if they tell you there's not much they can do, you want to communicate that in an email afterwards and say, can you please confirm that there's nothing that you can do at this point in time? The reason you do this and the reason you look to get a response back from them that's in writing is so that you can put it in your file, and if your lawyer determines, or if you later determine that insurance is applicable, you don't want the insurance carrier to come back and say, well, you should have notified us earlier. And you say, well, I phoned you. And they say, we have no record of that phone call. You want to have a clear written communication in your file as to your communications with your insurance carrier. And even then, even if your insurance carrier takes on your claim, you still want to engage your own legal counsel. So you want to have legal representation, but you also want to have your own legal counsel. And why do I say that? It's because the insurance carrier's lawyers are out to protect the interests of the insurance company, first and foremost. Yes, they're there to protect your interests also, but you want to be clear. And you want to have somebody who's going to give you a clear and concise answer as to whether or not this is in your best interest. Not the combined best interest of the insurance company and yourself. It is your best interest. So you want to have your own lawyer. And now when it comes to talking about the lawyers, you want to have the appropriate lawyer. You want to have one who is experienced and admitted to your particular jurisdiction and its courts. Now, there are lots of lawyers out there, but you almost want to always look for somebody who's a specialist, who's got experience in the work that you're dealing with, so that you are effectively being represented. But also, even if you're paying slightly more for that particular lawyer, you are paying more on the basis of the hours that they put in. But since they understand that they know what they're dealing with, you are looking for them to put in less time or more focused time, because they're not learning something that they're unfamiliar with, but this is something that is familiar to them. They've worked on it before and they know how to deal with it. It makes a world of difference. It makes it completely different where you have somebody who's knowledgeable in that area, competent in that area, has dealt with it before, who can understand your business, understand the dispute, understand the angles, and has a process by which they know, and they will work with you to show you the path that they're looking to take. Because you cannot just simply go to a lawyer and just say, deal with it. You want to be understanding, so you get the competence, the satisfaction that your case is being properly handled, that they have a game plan, that they're going to work with you, that they're going to pull in the stuff, they're going to work with yourself, they're going to make the process work to your advantage. And that is critical. If you don't have that confidence, if you simply delegate and walk away from it, it's going to be exceedingly problematic for yourself, and it's going to be challenging. So you want to be engaging that lawyer and retaining them once you found the right lawyer, and you don't want to let your timeline slip. Remember, when you look at most complaints, statements of claims, lawsuits, they have specific timelines within which you have to file your defense. You don't want to be losing on those. You don't want to be losing on other opportunities, such as filing counterclaims and cross-claims that might also have time constraints. You want to be operating properly within them. And with a knowledgeable lawyer, you can make sure that you're dealing with them. Lawyers are often able to contact their fellow lawyers who are on the opposite side, and where necessary, get the appropriate deferrals in time so that you can mount the full defense that you're looking for. So, those are but a few of the key considerations that you need to be undertaken when you receive a lawsuit and are being sued, because there is naturally a lot more to it, but these are some of the key considerations you should be taking in and moving forward on immediately, expeditiously, and with a clear conscience and focus. I trust you found this YouTube video informative. For legal matters pertaining to the work that we do, as seen on our website, please do not hesitate to contact ourselves, and we wish you all the best with these matters that you face should you be confronted by receiving a lawsuit, statement of claim, complaint, and finding yourself under suit. Thank you.